Hello, and welcome to New EEOC Guidance on the Use of Criminal Records in Employment Decisions. My name is Jacob, and I'll be in the background answering any WebEx technical questions. If you experience technical difficulty at any time during this WebEx event, please submit your technical issue into the Q&A panel, and I will try to assist you. You may also contact WebEx Technical Support at 1-866-229-3239 for further assistance. Please note that as an attendee, you are part of a larger audience. However, due to privacy rights, we have chosen not to display the number or list of attendees to everyone on the call today. As a reminder, today's call is being recorded. We will be holding a Q&A session at the conclusion of today's presentation. You may ask an online question at any time during this event by simply typing your question into the Q&A panel located on the right-hand side of your screen, or by clicking on the question mark icon located on the floating toolbar in the bottom right of your screen. Just type your question into the text field and click Send. Please keep the Send to defaulted to all panelists. This presentation has been prepared by Seyfarth Shah, LLP, for informational purposes only and is not legal advice. This information is not intended to create, or receipt of it does not constitute, an attorney-client relationship. Participants should not act upon this information without seeking professional counsel. The material discussed in this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and specific legal questions you may have. Any tax information or written tax advice contained herein, including any attachments, is not intended to be and cannot be used by any taxpayer for purposes of avoiding tax penalties that may be imposed on the taxpayer. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce you to one of your presenters for today, Pamela Devada. Pamela, you now have the floor.
Thanks very much, Jacob, and welcome everyone to Seyfarth Shah's webinar on the new EEOC enforcement guidance on the use of arrest and convictions in employment. As Jacob said, my name is Pam Devada, and myself and my partner Fritz Smith are happy that you could join us today. As most of you know, the guidance that we're discussing came down yesterday from the EEOC, and while it's not binding on employers like a regulation or statute would be, this really is what the EEOC uses to investigate claims of discrimination against employers using criminal history. We've already seen how expensive and challenging it can be for employers dealing with these issues, as evidenced by the conciliation agreement with the EEOC and Pepsi Beverages for $3.13 million earlier this year. And while this is not binding, the guidance will likely result in more EEOC action, so employers should be aware of this. On today's webinar, we have 4 agenda items. Number 1, what prompted the guidance. Number 2, a little bit about the public meeting that occurred yesterday for some background, an overview of the specifics of the guidance, and really what employers should consider and best practices that the EEOC has opined in the guidance for employers using arrest and conviction records. Given the size of our audience today, we're not going to be able to entertain questions, but please understand we will be having more dialogue through publications, and also we encourage you to call either Fritz or myself or any attorney at Seyfarth Shah if you do have questions on these issues. And with that, I'm going to turn it over to my partner Fritz to talk a little bit about what prompted the new guidance. Fritz?
Thanks, Pam, and thank you everyone for joining us this afternoon. This guidance is a manifestation, in part, of the EEOC's E-Race initiative. And the EEOC's E-Race initiative came out in 2006, 2007, and it's designed to improve the EEOC's efforts to ensure that workplaces are free of race and color discrimination. Specifically, the EEOC has stated that it is going to devote resources to identifying issues, criteria, and barriers that contribute to race and color discrimination. It's going to explore strategies to improve the processing and litigation of race and color discrimination claims, and it also hopes to enhance public awareness of race and color discrimination in employment. There are 5 main goals of E-Race. I'm not going to go to them in detail, but very quickly, they are, number 1, to improve data collection and data analysis, in order to identify, track, investigate, and prosecute allegations of discrimination. Number 2, improve quality and consistency in the EEOC's charge processing and litigation program. Number 3, and this is important for purposes of today, develop strategies, legal theories, and training modules to address emerging issues of race and color discrimination. Number 4, enhance the visibility of the EEOC's enforcement efforts in eradicating race and color discrimination. And certainly this guidance is accomplishing that. There's been a flurry of activity already in the past 24 hours on this guidance. And 5th, the Commission hopes to engage the public, employers, and stakeholders to promote voluntary compliance to eradicate race and color discrimination. For many of us, labor and employment lawyers, HR professionals, the EEOC's race initiative has manifested itself in this very area and in challenges to employers' use of background checks. Next slide, Pam. In the guidance, you see the EEOC laying out various arguments pertaining to employers' use of criminal history information. There's a discussion about disparate treatment, which involves the typical Title VII analysis. We're not going to spend a lot of time on that. I'll simply note that, in other words, the EEOC is emphasizing what we all know, and that federal and state law mandates that we treat people of all protected statuses fairly and consistently. Now, one of the underlying premises of the guidance is the EEOC's assertion that there is national data that supports the use of criminal history and that it has a disparate impact on certain minority groups based on race and national origin. The argument of the EEOC and others is that people of certain races and national origin, specifically African Americans and Hispanics, are arrested and convicted more frequently than others outside of those groups, and that employers' use of such information has a disparate impact on certain minority groups. Now, the EEOC, as part of its investigation process, and for some of us, it's consistent with what we view the shoot first, aim later tactics in cases in other contexts, has flipped the burdens of the disparate impact analysis, and it assumes that criminal record exclusion policies have a disparate impact. So what is disparate impact all about? Well, disparate impact theory first was recognized by the United States Supreme Court in a decision from 1971 called Griggs versus Duke Power Company. And at issue in Griggs was an aptitude test that was used during the hiring process. And in Griggs, the Supreme Court stated that plaintiffs under Title VII can make out a viable claim of employment discrimination without alleging or proving discriminatory intent. It was a new concept, and it found its way eventually into the statute. The current version of the disparate impact theory, which changed as a result of other Supreme Court decisions and the Civil Rights Act of 1991, is found in Title VII at 42 U.S.C. 2000E-2K. The disparate impact theory proceeds in 2 steps. A plaintiff must prove that a facially neutral policy discriminates against members of a protected class, and a defendant can overcome a showing of disparate impact by proving a manifest relationship between the policy and the job performance. And this manifest relationship evolved into what is now known as the business necessity defense. So on page 10 of the EEOC's enforcement guidance, it talks about Griggs. It talks about the disparate impact theory. And as I said, the EEOC, at least in the investigation context, has flipped the burdens around. While in a litigation context, the plaintiff bears the burden to establish disparate impact. In the EEOC's investigatory mindset, that burden falls squarely on the shoulders of the employer. And the EEOC is going to assume that there's a disparate impact unless an employer can show evidence that there is not. The guidance also makes it clear that if you have a diverse workforce, that is not going to assist you in defeating a disparate impact claim. The Commission also stated in the guidance that it's going to look at an employer's reputation in the community for excluding individuals with criminal records. It's going to take a look at recruitment practices. It's going to take a look at publicly posted notices, individual testimony, employer statements, and taking all of those factors into consideration, it's going to determine the persuasiveness of that evidence on a case-by-case basis. The burden shifts, at least in a litigation context, and an employer must prove business necessity and job relatedness, and that there are no other less restrictive means of obtaining the same information. One of the leading cases in this area is a case called L versus Septo. We won't go into that decision at length, but know that at issue in L was the Transportation Authority's criminal background check policy that prohibited, among other things, the hiring of applicants for driver positions who had been convicted of violent crimes. And L, the plaintiff in that case, had a 40-year-old conviction for felony murder. The EEOC in its guidance talks a little bit about L, but doesn't place too much emphasis on it. There are a couple points that I want to make about L. They're, I think, buried somewhat in the guidance, but they're important for all of us to think about in examining our policies and practices and risk. Unlike performance criteria, criminal background checks often involve issues of safety and the risk that applicants and employees may pose to their coworkers and to other people who are at-risk populations. And in L, the Third Circuit said that it's going to require, in this kind of analysis, that the policy under review accurately distinguish between applicants that pose an unacceptable level of risk and those that do not. Another point that flows from the L decision, and those of us who litigate a lot of disparate impact claims know, is that these cases often rise and fall on expert testimony and the battle of experts, which is an expensive proposition for anyone who finds themselves embroiled in litigation. That's the disparate impact theory in a nutshell. Pam, I'm going to turn it over to you to talk about the EEOC's past focus.
Thanks, Fritz. As Fritz indicated, the EEOC has certainly been looking at the issue of criminal history for many, many years. And although we have this new guidance now, they've been focused on this issue way back since 1987 and arguably even before then. In 1987, the EEOC issued policy statement on the use of criminal history generally. And the factors that stemmed from that policy guidance came from a case that was held in the Eighth Circuit in 1975 called Green versus Missouri Pacific Railroad, which is cited in the guidance. One of the main reasons, I think, for the new guidance was the L versus SEPTA case, and then also some information with relation to the higher amounts of incarceration, as well as the E-Race initiative. So that's really the impetus of what we're doing in terms of having new guidance now from the EEOC. The EEOC has been pretty quiet about the use of arrest records, except in 1990 they did have a policy statement of the use of arrest records. It didn't say very much. That's really the only information that they have publicly stated about the use of arrest records. We saw in 2006 and 2007, as Fritz discussed, the E-Race initiative began. And then it really culminated last year in July. On July 26th, the EEOC held a public meeting on the use of arrest in criminal history as a barrier to employment. The EEOC had public testimony from a variety of stakeholders, and it was pretty clear for anyone who attended that meeting and or read the notations from that meeting that there was a cry for more guidance, at least from advocates against employers using criminal history in employment decisions. So all sides pointed to the fact that there would be guidance, and indeed yesterday that became true. The other thing to notice is that the EEOC has actually been very vocal in terms of enforcing criminal history and the fact that it's their opinion that the use of criminal history has a disparate impact. Two nationwide pattern and practices cases that they brought in the last couple of years, one EEOC versus PeopleMark that ended up resolving itself, and the EEOC was actually given a slap on the wrist for $750,000 in punitive damages in that case for bringing a frivolous case, and then the EEOC versus Freeman case that deals with the use of criminal records and credit records, and that's pending in the District of Maryland. With the new guidance, we think that there will be more cases coming down the pike. In terms of the guidance, there have been some non-legal challenges, and what do we mean by that? Although the public meeting was held last July, there wasn't really a lot of other public information and discussion on the fact that the guidance was being written. And that has given rise to some non-legal challenges. Most recently, you'll see these are three letters that were written in the past this month. Number one, on April 2nd, the U.S. Chamber of Commerce wrote a letter to the EEOC specifically saying that they wanted notice and comment period and a review by the OMB. Because this is such a sea change and because this new guidance will affect most, if not all, employers, the Chamber was concerned about the guidance limiting employers' use of criminal history. Senator Enzi also joined and wrote a letter demanding specifically that the EEOC not issue guidance and not have a vote on any guidance until it was, number one, publicly circulated, number two, had a comment period be allowed, and that the OMB had the opportunity to review. Many people thought that these letters and then the final letter also dated April 19th that was signed by over 47 large employer and other associations and industry groups also seeking a notice and comment period might have some effect on either delaying a vote or potentially having a notice and comment period. Obviously, the EEOC was not persuaded by these non-legal challenges to the guidance. It certainly remains to be seen what's going to happen now that the guidance has been published. And I think we're going to talk now about the public meeting and what happened there, and specifically Commissioner Constance Barker's comments will give a flavor of at least her dissent with regard to the fact that there was no public availability for notice and comments. So we're going to talk a little bit now about what happened yesterday, and then we're going to jump into the guidance. So for everyone's knowledge, yesterday at 9:30 Eastern, there was a public meeting. Generally, that public meeting is recorded and if at least not publicized and televised after the meeting, the transcripts of those meetings will be made available. It was extremely well attended. Not surprisingly, when it came to a vote on the specific criminal history guidance, it was not unanimous. For those of you who may know, the commission is made up currently of 5 commissioners. 3 are Democrats, 2 are Republicans. However, Commissioner Ishimaru is resigning his post at the end of this month, which is one of the reasons why we think that the challenges to this guidance didn't have any effect, because everyone knows if you've got a 2-2 split, then it becomes hard to pass any guidance. Commissioner Barker was the only commissioner who opposed the passing of the guidance. I want to talk just for a second about the specific statements that were given at the public meeting, because I think it's helpful to give an insight to employers who are actually trying to navigate these turbulent waters based on the specific guidance to know the philosophy behind some of it. First of all, the Office of the General Counsel spoke and talked about the disparate impact and the high number of incarcerations that has risen in the past couple of years. Also discussed the fact, frankly, that about 90% of employers are conducting background checks for employment, such that the Commission felt that this guidance was absolutely necessary. Commissioner Ishimaru went first as the outgoing commissioner, and in terms of statements, specifically stated that there are 100 investigations that are currently pending, and this is before the guidance has even been issued, in the EEOC based on background checks. And Fritz and I and many of you out there are extremely familiar that the EEOC is looking at this issue on a nationwide basis. This is a systemic initiative, and frankly, we think that this guidance is just going to give more fuel to the fire. He also mentioned that the guidance is in accord with Obama's Second Chance Act and trying to get individuals back into work based on the slowdown in economy over the past couple of years. Commissioner Barker, as I discussed before, was extremely concerned about the lack of transparency in the process. She mentioned the letters by Senator Enzi and the other groups that we specified, and in her opinion, she actually said to the public audience that if she was in business, she would, quote, never run a background check again. I think that that was her way of showing her strong dissent. We're here to tell you that it's not all doomsday, and certainly what I don't think should be taken from this webinar and from the guidance is that all criminal records should be stopped in use of employment, or that employers should change their practices to not ever use criminal records. And indeed, the guidance specifically says that, as did the chair during the meeting. Commissioner Feldblum, a Democratic commissioner, discussed the history of EEOC and also really went to painstaking lengths to stress the bipartisan nature of this guidance, specifically stating that she and Commissioner Lipnick and others had met with many industry groups, I think as an event, obviously, to show that perhaps there was more transparency than some may have thought. But she certainly did go to painstaking lengths to say that. Commissioner Lipnick, she's a Republican, the other Republican commissioner, discussed that while the individualized assessment that we'll get into in great detail was problematic, that there may be times that may not be needed. She specifically pointed out two situations, actually, one of them being where there's a violent crime against a child for a child care provision. We're going to talk about individualized assessment and how that's really a sea change from the prior guidance, and to me, that's the most concerning takeaway of the new guidance. And then finally, Chair Berrien talked about the fact that this guidance should not prohibit the use of criminal background checks. It remains to be seen what the fallout of the guidance is going to be, but certainly it definitely places more burdens on employers to make sure that they do comply with the guidance. And there are going to be some large hurdles that employers such as yourselves are going to have to overcome, and certainly evaluate your policies and processes and your current practices when you're using criminal history based on this information. So without further ado, we're going to dig in now and spend the rest of our webinar giving an overview of the specifics of the guidance, and then we're going to talk about the best practices that at least the EEOC has laid out, as well as what you should be considering as employers based on this new guidance. I'm going to go ahead and give it back to Fritz.
Thanks, Pam. Back to the job-related and consistent with business necessity defense that we were talking about earlier. And the enforcement guidance certainly provides more analysis from the EEOC about this standard. And in the eyes of the EEOC, there are two circumstances in which it believes that employers can consistently meet the job-related and consistent with business necessity defense. Number one, the employer can validate its policy, particularly for a position or positions that are being scrutinized by the Commission, and validating the policy pursuant to the uniform guidelines and employee selection procedures, which have been in place for some time and issued by the EEOC. Specifically, the EEOC is going to be looking for data or some type of analysis about criminal conduct and a significant tie or relationship to subsequent work performance, or as I noted from the L decision, the risk that an employee's or applicant's prior criminal history has on safety. In keeping with this particular validation method to justify a policy, an employer is going to have some type of study. And if it finds itself embroiled in litigation with the EEOC or some other party, it's going to need expert testimony. Now, according to the guidance, these types of studies are rare. I don't know what type of research the EEOC has done and that caused it to conclude that, but that's its current opinion regarding the breadth of analysis that's already been done by the academic and other communities. Alternatively, an employer can develop a targeted screen considering the 3 green factors, which are nothing new. They've been in place for some time, and many of us have been counseling employers to use those or some of the other tests that have been set forth by similar state laws. You need to focus on the nature and gravity of the offense. You should focus on the time since the conviction and or completion of the sentence, and certainly focus on the nature of the job held by the employee or sought by the applicant. You also need, and this is something very new from the EEOC, and Commissioner Lipnick gave us a little taste that this might be coming at a meeting hosted by the U.S. Chamber of Commerce in early March. You're going to need, in addition to the targeted screen, to go through an individualized assessment to determine if it's job-related. And while the Commission has stated that it's not going to require individualized assessment in all circumstances, it's made it clear in the Q&A that accompanied the guidance that a screen that does not include an individual assessment process is more likely than not to violate Title VII. What's also clear from the guidance, and we've known this for some time, is that the EEOC frowns upon bright line rules. Any bright line rule that takes out a group of people for certain types of convictions is going to be challenged by the EEOC. There's no doubt about it. And what we see in the guidance is additional detail as well as to what these 3 green factors really mean. With respect to the nature and gravity of the offense, the Commission is telling us to focus on the harm caused, the actual legal elements of the crime, and the classification of the offense, whether it's a misdemeanor or felony. With respect to time since the conviction and or completion of the sentence, the EEOC would like all of us to engage in some evaluation regarding recidivism. Now, one of the things that there's an ongoing debate right now deals with this issue of recidivism and some of the 7-year and other types of rules that we see in various statutes. And what the studies appear to be showing is that there's really no scientific basis for these 7-year rules, although many of us have been recommending that employers use them. They have a basis in the FCRA and other statutes. But truth be told, according to social scientists and other academics and folks who study recidivism, there's no magic or perhaps logic to 7 years. And the threat of individuals committing crimes, again, vary based on the original crime committed and a whole host of other factors. And the likelihood of committing crimes down the road may be shorter than 7 years. It may be much longer than 7 years. So we're all going to keep our eyes out for the continued studies that we hope are being done regarding recidivism and use them in analyzing our policies and our risk assessment. With respect to the nature of the job held or sought, this isn't anything new to all of us, and it's a maxim that holds true in so many other contexts. You got to look at more than just the job title. You need to focus on the specific duties and the essential functions in the environment. Pam, I'm going to turn it back over to you for a more in-depth discussion of the individualized assessment process.
Thanks, Fritz. I mean, one of the big challenges with regard to the detail of these three factors is, looking at, as Fritz said, the evaluation of recidivism. There is no consensus among the academic community of what is the correct viewpoint of recidivism. And for those of you who don't know, when we talk about recidivism, what we're meaning is the likelihood of someone who has been convicted of a crime to re-offend and to have a bad action or be convicted in the future or engage in another illegal activity in the future. And so while it's great that the EEOC has given more guidance on this, it's very challenging because there is no consensus on what, as Fritz said, what really is the true nature of recidivism and at what level and what crime, and so it's going to be challenging for employers to deal with. In my viewpoint, and what we're going to focus on now is the individualized assessment. In my viewpoint, this is absolutely the biggest change in the guidance. I think that it is going to make an employer's use of arrest and conviction records much more difficult logistically and procedurally. And before we get into that, for those of you on the phone who are eligible for CLE credit, continuing legal education credit, I'm going to stop and give the code. It is SS7392. Again, the CLE code is SS7392. All right, so as Fritz pointed out, what the EEOC has said is in order to prove job relatedness and business necessity, you either have to have that validation study, which is going to be very, very difficult to do, or you have to look at the three factors, which we talked about, and have an individualized assessment. The guidance specifically recommends that there be an individualized assessment to reduce your risk of a disparate impact claim. And it's interesting because the guidance specifically says that Title VII does not require an individualized assessment. However, the guidance goes on to say that employers will need to evaluate if there are criminal offenses that have a, quote, demonstrably tight nexus to the position in question, such that the individualized assessment isn't necessary or can be circumvented. In her opening remarks at the public meeting yesterday, Commissioner Victoria Lipnick set this forth and specifically indicated that she wished that the guidance would have more detail, that individualized assessments were not needed in every case. She gave the example, as we talked about before, of someone who was who had been convicted of a child-related crime working in a child care facility. It certainly makes common sense that an employer would not have to actually have an individualized assessment and do a determination in that situation. What do we mean by individualized assessment? We basically mean either an employer doing their own investigation and at the very least talking to the person. So it's either going to be getting more information on their own from talking to the individual or requesting information from that applicant or that individual, and or doing their own evaluation and investigation of other factors. And the guidance specifically sets forth 7 pieces of evidence, if you will, that an employer should review. These 7 pieces are very similar to the New York law with regard to criminal history, which is New York Article 23A of the New York Corrections Act for those of you who have employees in New York. What the EEOC says is that if you are going to be taking action based on criminal conviction, you should review these 7 factors for evidence. Number 1, the facts or the circumstances surrounding the offense or the conduct. Were there extenuating circumstances? Was the person in the wrong place or the wrong time? Number 2, the number of offenses. Was this a one-time mistake or is this a repeat offender, for example? The age at the time of the conviction or release from prison. This one always strikes me as interesting because, the EEOC is charged with enforcing not only Title VII but also the ADEA, the Age Discrimination in Employment Act. Yet, in this factor test, they're specifically saying that employers should look at how old the person was when they actually committed the conviction. Evidence, this is a new one, evidence that the individual performed either the same type of work after their conviction without any incidents. So if you're hiring an individual for a manufacturing job and that individual has successfully completed a manufacturing job after they were convicted and released from jail, for example, before they came to work for you, you need to take that into account. The length and consistency of employment before and after the offense, which is similar to the one before, and any rehabilitation efforts and whether the individual is bonded under a federal, state, or local bonding program. The issue here is having an individualized assessment is going to require, at least under the guidance as we interpret it, that an employer actually speak to the individual and or do their own investigation. And as we all know, that's tremendously burdensome and frankly logistically difficult, especially if you are with an organization that has a large number of employees or that has a lot of attrition. A practical reality of this is if you use a background screening company, for example, you may or may not be able to have a hiring criteria or matrix that has a definitive decision or an ineligible, for example, because I don't know how you can have a matrix that automatically eliminates someone and still comply with the individualized assessment. Very challenging. Again, this is going to be one of the hardest things for employers to deal with under the new guidance. The guidance also talks about ban the box. For those of you who have heard this before, there's been a number of states that have done this ban the box. Basically, the legal theory is that you shouldn't be asking for a criminal history on an employment application, and so we talk about this as banning the box where someone checks whether or not they have been convicted of criminal history. The guidance says that employers should not ask about arrests or convictions on the job application. However, it then goes on to say if an employer does ask about an arrest or a conviction, it should only be relevant to the specific job at issue. And practically speaking, it's going to be interesting to see how the EEOC enforces this. Because right now, if you are a nationwide employer, you generally will ask about criminal history on an application for many purposes, not the least of which is to see if someone will falsify their application. And you may have to have different employment applications or different criminal history questions for each specific job position or each class and category of information. What the EEOC says is that you should only be asking about information that is job-related, and you should not be getting information from your background screening provider that is outside of what would be job-related. That's a sea change. Most employers that we deal with ask about criminal history on either an employment application or some part in the process. It's interesting, there's no clear guidance on when it would be acceptable. What we would say is consider when you want to ask about criminal history. Should it be at or after the time of the interview? Should it be before conditional offer or after conditional offer? I think for a lot of companies, waiting until after a conditional offer may defeat the purpose of asking at all. Another very hot topic of the guidance is the use of arrest records. Similar to the individualized assessment, this is one that causes me grave concern based on the fact that we counsel and litigate with employers every day with regard to these types of issues. Right now, the guidance says that the use of arrest records has a per se disparate impact. So if you are using arrest records, that would have a per se disparate impact, and as Fritz explained, then the burden would shift to show that you do have business necessity and no other least restrictive alternative. The problem is that the guidance doesn't distinguish between arrests that happened 4 years ago and just were never closed out and something that is pending. A pending charge, in my perspective, is something that has a court date, for example. If someone was arrested and charged with sexual assault 2 weeks ago, you may not want that individual coming back to your workplace, for example, unless and until you make a decision. And this is what employers have been struggling with for years. What the guidance does say is it gives employers the ability to not rely on the arrest, but to actually rely on the underlying conduct if that conduct would make the individual unfit for the position. So, for example, if someone admitted to you as an employer that they were engaged in the distribution of illegal drugs, for example, and they were arrested for it, you could take action on the fact that they admitted to and were engaged in the distribution of illegal drugs, if that was job-related. The issue and the challenge for employers is the only way that an employer is going to learn about the conduct is either to investigate and do their own independent investigation of the underlying facts by talking to other people who were involved, which is going to be very challenging, or at the very least talking to that individual, which is very similar, again, to that individualized assessment. The one saving grace in the guidance that we have not had before and employers have really been challenged with is at least the guidance in example number 4 talks about the fact that an employer can put an individual on an unpaid administrative leave while the employer is sorting out the details and getting to the bottom of the underlying conduct. What still remains, however, is that employer is going to have to make a character reference and decision. I mean, you're going to have to determine whether or not the individual that you're talking to is credible. And that's going to be very challenging for employers to do. I'm going to go back to Fritz now, and he's going to talk a little bit about compliance with other laws.
Okay. Thanks, Pam. We're getting close to the wire here, so I will try to breeze through this particular section. The guidance spends an awful lot of time, 4 to 5 pages, talking about the interplay of the guidance and other federal laws and regulations. And it acknowledges that compliance with these federal laws and regulations disqualifying convicted individuals from certain occupations can be a defense to a charge of discrimination. It cites to a federal law that excludes individuals who have been convicted in the previous 10 years of specified crimes from working as a security screener or otherwise having unescorted access to secure areas of airports. Query what type of research and data that law has to support the 10-year disqualifier, but it's out there. It also mentions laws dealing with child care workers in federal agencies or facilities, bank employees, port workers, and further talks about the interplay of the guidance and other statutes that regulate occupational licenses, statutes dealing with the waiver of federally imposed occupational restrictions, security clearances, and working for the federal government. Now, what I found surprising about the guidance, amongst other things, is that, to my knowledge, there's one Supreme Court opinion out there that talks about background checks. Now, granted, it's in the federal government context, and it talks about the federal government's background check inquiries. It's a case called NASA versus Nelson that came out in 2011. But the Supreme Court said the following in the NASA decision. Like any employer, the government is entitled to have its projects staffed by reliable, law-abiding persons who will efficiently and effectively discharge their duties. It went on to state that questions about illegal drug use are a useful way of figuring out which persons have these characteristics. I've not had a chance to read all of the footnotes to this guidance, but I don't see a reference on first glance in the body of the document to the NASA opinion of the Supreme Court. The guidance goes on to talk about the interplay between Title VII and state and local laws, and states that complying with some state and local laws and regulations will not shield employers from Title VII liability due to Title VII's preemption of state and local laws. In my opinion, this part of the guidance is based on a tortured reading of Title VII's very, very narrow preemption provisions. And in counseling clients going forward about the interplay between Title VII and the state statutes that are out there, I'm certainly not going to advise employers in certain industries, schools, healthcare, childcare, nursing homes, to ignore their state law obligations to conduct criminal background checks of applicants and employees, and to deny employment to individuals who pose a threat to at-risk populations. The takeaway from this particular section is that employers need to evaluate whether these other laws on which they may be relying as a defense to run criminal history background checks and take adverse actions against applicants and employees are preempted by Title VII. In my opinion, more often than not, we're going to come to the conclusion that there is no such preemption. Pam, in our remaining time, you want to take the lead on best practices?
Sure, happy to do so. The EEOC's guidance actually sets forth a number of, in their opinion, and this is their terminology, quote-unquote, best practices. They don't give very much interpretation. They, take the last 2 pages of their guidance on page 25 and 26 of the guidance to set forth these best practices. Some of these are easy. We've talked about them and highlighted them already, and some of them have already been in play for many, many years. We're going to go through them and give you some of our thoughts in terms of takeaways for what you need to do. The first, as Fritz mentioned earlier, is no bright line policies. You have not been able to, for many, many years, have a policy that says something like, we don't hire felons. The EEOC is going to say that that has a disparate impact and that there is no job relatedness or business necessity. No big change there. The second thing is the EEOC, not surprisingly, talks about the fact that it is a best practice to train people who are going to be dealing with the criminal conviction piece of hiring, managers, hiring officials, and other decision makers, about Title VII and the prohibition on employment discrimination. Certainly, anyone who is in an HR capacity or in a hiring capacity should already be aware of Title VII. What we might recommend is that this guidance and or your policies and procedures with regard to certain hiring decisions be communicated to those individuals so that they can be informed with at least what your company's practice is. One of the things that I think is important is, if you use a third party to apply hiring criteria, you might not be able to do that anymore based on your bright line policy issue and the individualized assessment. And they don't talk specifically about individualized assessment and best practices, but clearly we've done a dive in terms of what the EEOC guidance says on that. I am in no way, shape, or form saying that the use of matrices is no longer allowable under this guidance. I think it absolutely still is, but I think it's going to be challenging for employers to have a background screening company do a red or a disqualification, as we talked about.
Yep. Pam, this is Fritz. I think you and I are in agreement that it's undeniable that this guidance is certainly going to impact how employers and consumer reporting agencies work together And one of the things that Pam and I are going to do with the support of our team at our firm is think about how this guidance, particularly in the individualized assessment requirement, can dovetail with some of the obligations that flow particularly to employers and, in some instances, consumer reporting agencies under the Fair Credit Reporting Act and other similar state statutes.
One of the things that we've discussed already is that, obviously under the Fair Credit Reporting Act, employers who are using a third party to get this information have requirements if they're going to take adverse action. And there may be a way that we can use the pre-adverse action letter to assist in doing some individualized assessment. Again, we're going to be getting more information about that and look for more things to come from Fritz and myself and our team. In terms of the next step of best practices, the next category of information is developing a policy. With the passage of this guidance, as well as many other state laws, for example, the Massachusetts Corey Law, which goes into effect on May 4th, if you don't have a policy with regard to your use of criminal history, you need to. And you need to seriously think about having something written so that it will be self-serving and can assist you, because that's the first thing that any investigator at the EEOC is going to ask for, and we've seen it time and time again. Some of the main points that the EEOC guidance talks about is when you do develop a policy that you should make sure that it is narrowly tailored and only request information that is job-related. That's really a sea change, and that's not certainly what is standard with in the industry of background screening. More often than not, employers ask for information that they are legally entitled to, or information going back, for example, for a certain period of time, like 7 years. I think that this guidance potentially says that you should only get information that relates to a specific position in question. It's going to be much more burdensome for employers. And that dovetails into the second bullet, which is identify the essential job requirements and the actual circumstances under the jobs. It's challenging, I think, when you have a large organization with many, many, many jobs and positions to identify which specific criminal history is going to be important to that specific job. And it may require outside guidance based on studies, based on having an IO psychologist or someone else come and evaluate that. Again, another burden for employers. In terms of the specific offenses that may demonstrate unfitness, again, it's all about the same issue here. It's all about determining what is going to make someone unfit, what criminal history is going to make someone unable or unfit to do a specific job at issue. In terms of the duration of exclusions for criminal conduct, what I read that to mean is how long are you going to go back in terms of information? How far are you going to get information, and how far back does it make sense to look at a criminal conviction? We thought that the guidance actually might be worse than it is, and it might actually have a bright line recommendation that employers not go back for a period of time based on some of the recidivism studies. Luckily, the guidance does not have that, and I think that is a win for employers. That being said, you're still going to have to implement individualized assessment processes for more than most of your decisions. There's only be very, very rare occasion where, in my opinion, you're not going to have to do that. The last three are interesting because the last three is really a record-keeping requirement and sort of shoring up your justifications, if you will, for having these policies and procedures. I think the EEOC investigators, at least, are going to be asking for, and frankly, Fritz and I have already seen this, asking for items such as, what did you base your opinion that this conviction was job-related on? What study? What seminar? What's your justification for having that process and procedure? And then record keeping of any consultation or research that you did when crafting your policy and procedures. And again, we mentioned the training hiring managers already.
Absolutely. That's already a common request that we're seeing in requests for information and subpoenas from the EEOC with challenges to background screening policies. And
then the final two best practices that the guidance specifically calls out is, again, sort of the ban-the-box issues, but it goes a little bit further in the best practices, because it says, regardless of when you ask the question, if you are going to ask a question about someone's criminal history or records, you should be limiting that to what would be job-related. So, for example, instead of asking about any and all felony or misdemeanor convictions that the individual has had ever or in a certain period of time, this seems to be a recommendation as a best practice that you narrowly tailor your question to specifically ask about only violent crimes in the last X number of years relating to a specific job, for example, and having to do that analysis. Again, the other issue that we've seen time and time again from the EEOC is that this barrier of a criminal history question may thwart applicants from applying. Part of the issue in the E-Rates initiative, as we've discussed, is that if applicants feel like they will be excluded from a job, they might not apply, and that in and of itself could be deemed to be disparate impact under the EEOC's analysis. And then certainly last but not least, and we've heard this time and time again, is the confidentiality of records. Keeping the information about criminal records of applicants and employees confidential and only using it for the purposes for which it was intended. People ask us all the time, should we be keeping this information in the personnel files? And while there's no definitive guidance on that, it's important to understand that if there's someone who has a criminal history and you've decided to hire them, is it really anybody's business? Frankly, that they have that criminal history, and so employers may be well suited to consider keeping that in a separate and distinct location while still maintaining that information. We certainly have covered a lot of material today. Again, this guidance is very new. It's a little bit more than 24 hours old now since it's been publicized. Our team, we've got a background screening, compliance, and litigation team at Seyfarth Shaw that is going to be giving some new communications. Look for those in the next couple of days and in the coming weeks. We also are recording this session, so for those at your offices who have not had an opportunity to join us for the webinar today, we should have that available tomorrow, as well as the PowerPoint as well. So with that, we are at the end of our time, and Fritz and I would both like to thank everyone very much for attending. We hope you have found this extremely useful, and we will certainly be in touch. If you do have questions, please feel free to reach out to either one of us or any of your contacts at Seyfarth Shaw. Thank you very much.
Thank you.